We are going to talk about one of the most important and honestly most relatable areas of tort law, liability in negligence. And don't let the legal jargon throw you off. Negligence just means someone's carelessness caused harm to someone else. For example, imagine you're at a cafe with your laptop and someone bumps into you, spilling coffee all over your keyboard. Is it just bad luck? Or could they actually be responsible for your ruined laptop? And that's where negligence kicks in. So, negligence law is all about figuring out when someone should pay for injury or property damage they caused. It's less about blaming people and more about fairness. Also about safety and keeping things running smoothly in society. So, why does it matter? Well, you'll see negligence everywhere with doctors and patients, drivers on the road, or when you buy something from a shop. Understanding negligence helps you see how the law protects both people and the public as a whole. So, first up, do I actually owe you a duty of care? The law doesn't expect any of us to be superheroes, but it does expect us to be sensible and not careless if someone else could get hurt. So let's look at the neighbour principle, Donahue versus Stevenson, 1932, very famous case. So picture this, Mrs. Donahue buys a ginger beer, pours it out, and surprise, there's a snail in the bottle. She gets sick and sues the manufacturer. The court said we all owe a duty to our neighbours in law. Basically, anyone who might reasonably be affected by what we do or don't do. I mean, if you were baking cakes for friends at college and you know some people have peanut allergies, well, you wouldn't add peanuts without a warning, would you? So that's thinking about your legal neighbours. Let's take a look now at the Caparo test. This is based on Caparo versus Dickman from 1990. So this test gives us 3 questions to help us decide if someone owes a duty of care. First of all, first question here, was the harm foreseeable? So could someone get hurt? Is there a close relationship, proximity? Are the 2 people connected in some real way? And the third question, is it fair, just and reasonable to impose a duty? So here are some examples. Doctors owe a duty to their patients. Drivers owe a duty to other road users. And manufacturers owe a duty to consumers. Let's move on to looking at breaches of duty. So let's start with that word. Breach. What does that mean in negligence law? Well, a breach happens when someone fails to meet the standard of care that a reasonable person would have shown in the same situation. In other words, it's when someone acts carelessly or doesn't take the precautions that most people would, and that leads to harm or risk to others. So it's not enough to owe a duty, you've got to actually breach it. So the law basically asks, did you act like a reasonable person would in the same situation? Now, the law isn't about expecting perfection, though. It's just reasonable care. And we can look at the case of Bolton versus Stone. So a cricket club had protective nets set up, but a ball still escaped and broke a window. Was that reasonable? Well, to be fair, yes. And the court said yes, because they had already taken some precautions. Let's now look at what affects the standard of care. How does the law decide what counts as a reasonable standard of care? And the answer isn't really a one-size-fits-all. Courts are going to look at several factors to figure out just how careful someone should have been in a particular situation, and here's what they consider. Well, how likely was harm? More risk means more care is needed. How serious could the harm be? If the consequences are big, the standard goes up. Were precautions practical? So reasonable steps are all that's needed, not the impossible ones. And finally, social utility. Sometimes risky actions are justified, like, for example, firefighters in an emergency. Here's a good example. So you've got the Paris versus Stepney case, where a man who already only had one good eye lost his sight entirely because his employer didn't provide him with goggles in the workplace. So the risk was small, but the possible harm was huge. He already only had one eye, so the employer should have been extra careful in that case. Causation. Okay, so someone owed a duty and breached it. We've got that far. But did their actions actually cause the damage? That's our next step. And we'll look at, first of all, the but-for test. So ask yourself, but for what this person did, would the harm still have happened? And if yes, then they're responsible. And if the answer is no, well, maybe something else caused it. They might not be liable. A good example is the Barnet versus Chelsea Hospital. So a patient would have died, in this case, even if the hospital had acted differently, so the hospital wasn't liable. So even if you can show that someone did actually cause the harm, the law doesn't just stop there. It also asks, should this person really be held responsible for everything that happened? And that's where legal causation comes in. The truth is that not every single thing that happens as a result of someone's actions will end up being their fault in the eyes of the law. Because, sometimes something totally unexpected happens in between, or the damage is just too far-fetched to blame on them. So in this part, we're going to look at how the courts decide when someone's responsibility ends, like when another event breaks that chain, or when the harm is just too unlikely for them to be held liable. So let's take a look at some intervening acts and remoteness. Intervening acts firstly then. If something completely unexpected happens in between, breaking the chain of events, then the original person might not be responsible. And secondly, we've got remoteness. So the harm must be a foreseeable result. In the Wagon Mound, the court asked if the type of harm was too remote to hold the defendant liable. Here's an example. If you leave a banana peel on the floor and someone slips, you caused it. But if a meteor crashes through the window and that's what makes them fall, then you're probably off the hook. Negligence doesn't just cover physical injuries like broken bones. It can also apply when someone suffers a mental injury, like severe shock or trauma. However, the law is much stricter about these types of claims. Not everyone who suffers mental harm can get compensation, actually, and there are special rules about who qualifies. So primary victims, they usually will qualify because they're the people who were directly involved in the incident and were in actual danger of being physically hurt. For example, if you survived a train crash and was at risk during the event, well, you would certainly be the primary victim or a primary victim. If you suffer mental harm because of what happened, then you may be able to claim. We've also got secondary victims. So these are people who didn't actually face any direct physical danger themselves, but they may have seen an event or its aftermath. Maybe they were bystanders, or perhaps they were family members who witnessed a disaster scene. So their claims for mental harm actually are much harder to win because they weren't the primary victims, were they? And because the law sets out extra requirements. We've also got some control mechanisms as well. So what does that mean? Well, it's to stop too many claims for psychiatric injury. So courts use these strict rules, they're called control mechanisms, to decide who can claim as a secondary victim. So you must be present at the scene or very close to it when the incident happened. So not just, hearing about it later. You can't be a secondary victim if somebody just told you something horrible that happened to them. Secondly, you've got to have a really strong, close relationship with the person that was actually hurt, like being a close family member. And usually you've got to directly witness or hear the traumatic event as it happens, not just see it on TV live or whatever, or hear about it afterwards. So in short, the law wants to make sure that only those who were really, really affected, either by being at risk themselves or being close witnesses with a really strong connection, only they can successfully claim for mental harm caused by someone else's negligence. Got a couple of key cases here. Alcock versus the Chief Constable of South Yorkshire. Now, you may know about the Hillsborough disaster. And after the Hillsborough disaster, people who suffered mental harm tried to claim. But the court said only those really close to the victims or who actually saw the events directly could get compensation. Seeing it on TV or hearing about it later wasn't enough. We've also got White versus Chief Constable of South Yorkshire. So this is the same case. Police officers at Hillsborough couldn't get compensation for mental injury either. So unless you're in physical danger yourself, even rescuers can't claim for psychiatric harm unless those strict rules are met. So here's a quick recap. You can pause and take a look at that. So some elements, definition and key cases that you need to be mindful of and commit to memory. And we'll just finish with some evaluation. So is negligence law fair? Let's pause and ask ourselves that. Is it clear enough? And here are the pros and cons. So you've got objectivity, first of all. The reasonable person test brings fairness and predictability. It's flexible. Courts can adapt to different situations. But we have some criticisms too. It's not always clear who counts as a neighbour or what's reasonable. The rules around psychiatric injury seem a bit harsh. Why are they limiting those claims so much, do you think? And then we've got legal cases can be slow and expensive, leaving people waiting for justice. There are some possible reforms to consider as well. So making compensation schemes more accessible, perhaps. Create clearer rules for psychiatric harm. That does seem to be a bit of a muddy area. And promote out-of-court settlements as well. That would certainly save some time and costs. So, think about how much we rely on others, doctors, drivers, teachers, to act carefully. If the law's not fair, then innocent people can suffer, or professionals might be scared off by lawsuits. So why does all this matter? Negligence law isn't just about winning or losing in court. It's about living in a community where we look out for each other. With freedom comes responsibility, whether you're walking your dog, if you're selling something, or just making a cup of tea for a friend. Well, the law encourages us to take care of each other. And that's a lesson that matters far beyond the classroom.